hear me now?
Yes, Mr. Salve.
Yes. But a short submission. I mean, Mr. Kaul has addressed your lordship on issues which perhaps don't arise really, if your lordship sit back and consider. What is it that your court is called to decide today? I mean, we have answered everything on merits, but Malad, if your lordship take a step back and see what is it that your lordships need to decide. The first step in this entire saga was...
Appearing for whom?
Mr. Salve, who do you appear for?
Yes, I'll just give your lordship the numbers.
Sorry, who are you appearing for?
Yes.
So the same set of parties.
There are many respondents.
So different respondents.
Yes,
Multiple
all
respondents,
Same,
yes.
another set of petitions.
Really, we have to only distinguish the case of the governor because the governor will be represented by
The solicitor, yes.
His client is not colored in any way. There is no confusion about whom I appear.
And the rest of Mr. Kaul, Mr. Salve, Mr. Jetmani, Mr.
We'll give appearances.
appearing for the individual
Yeah,
party.
that's right.
Fair enough, no problem.
Respondents. Okay.
And my lord, the only thing I wanted to broadly respond to is Mr. Sibal's broad submissions about what role the court should take onto itself to prevent political immorality. But this is a very slippery slope. And your lordships have always resisted the temptation in certain areas to go beyond a particular point. Interpreting the 10th schedule undoubtedly will be inspired by the objects of the 10th schedule, namely to bring in a degree of political morality in public life. But beyond that, my lord, I would submit for the court to embark on this journey would be extremely perilous because there are very delicate balances between institutions involved here. Mr. Uddhav Thackeray resigned. The governor called for a floor test of a sitting chief minister. There was no floor test held. The submission is if he had not called for the floor test and if this had happened and if that had happened, he would have won the floor test. A submission which your lordships should not even countenance for the reason we do not know what happens in that part of the world when it comes to defending the majority of a chief minister. And my lord, it becomes even more perilous in today's day and today's world of coalition politics. How do you know who would have supported whom on that momentous day? What if one of his coalition partners had said, sorry, I can see that you've really lost support of your party. We don't want to support you anymore. We don't know. And it is not for us to understand because these are matters beyond our understanding as lawyers. So, my lord, this entire submission that your lordship must assume a state of facts would have prevailed is extremely hazardous because this is in the realm, my lord, not of legal fiction. This is in the realm of the rough and tumble of politics. And I'm not suggesting any political immorality. My lord, why can it not be that two coalition partners say, we will not support you anymore. We've lost faith in your ability to steer the ship. We don't know whether that would have happened. Would it have happened? Would it not have happened? How can your lordships be invited to hazard that guess that if this had not happened, the but-for test, my lord, which we call in our commercial law for breach, the but-for test cannot apply here. Yes, if Mr. Thackeray had contested the floor test, if he had lost by 10, and your lordships felt 16 disqualifications were affected, the court could have said, we need to fix this problem because of our refusal to grant the test, because your lordship said we will not stay the floor test. We will make it subject to our judgment. And your lordships would have been in a position to correct what went wrong. My lord, I know it's a much more mundane world in boardrooms and in company general meetings, but The principle is the same. Somebody says so-and-so should not be allowed to vote. Your Lordship said count his vote separately. And we'll see what happens to the resolution. And the reason is, my Lord, suppose he had contested the floor test and lost by 70 votes. All this becomes academic. Yes, if they have defected, is the sin of defection purged? Maybe not. So, my Lord, that's the first point which I wanted to make. If that has happened, then if I'm right there, that your Lordship cannot and should not embark on any but-for assumptions here. Because we do not know what would have happened on that fateful afternoon. Please, my Lord, consider another scenario. I'm only giving these not because I'm saying this would have happened. I'm saying this could have happened. Only to persuade your Lordship not to go down this road. Let's take another scenario. These 16 were guilty of overt act. They did not show up for a meeting. Somebody says that constitutes abandoning your party. Another 20 people may have done something by which you say they have done an overt act. What do you know is lurking in the minds of others? Look at what happened, and I'm just to buttress this point, Manoj. Look at what happened when Shinde came for his floor test. 13 of hardcore so-called supporters of Mr. Thackeray abstained from voting, which basically meant it strengthened his hands. Now, these things happen in public life. How do you know how many more were not harboring the intention of walking away that day? So, Malad, these are all I'm saying is this is rank speculation as far as we are concerned. The politicians may feel that they knew what was going on. And we've had, and I'm just bringing it to your Lordship's notice, your Lordship know this, we've had a very strange situation in this very state, in this very formation, where one government was sworn in, and within 3 days that government fell and another government had to be sworn in. So, but these things happen. And the person who got sworn in as the Deputy Chief Minister with another formation became Deputy Chief Minister. These fast-moving political waters take different turns at different points. We are not to speculate about them. Now, if I am right there, then Malad, that should be the end of the matter. What is the Speaker's constitutional obligation? The general Bomai principle, which your Lordship has been shown in para 395 of Bomai, is that please, Mr. Speaker, do not do a mathematics. And Mr. Governor, please do not do this mathematics of but for. Call for the floor test. Let this be decided on the floor. My Lord, when governors have sacked governments doing head counts, your Lordships have taken him to task saying you're failing in your job. Why? Because it is not for the governor to count heads. What Mr. Sibal and Dr. Singhvi are trying to do is persuading your Lordships to count heads. Because unless you do a head count, your Lordship must then come to the firm conclusion that the but for these, Uddhav Thackeray would 100% have won. That's head counting. So, my Lord, what your Lordship said, the governor shouldn't embark upon. Now the judiciary is being asked to embark down that road. Nothing can be more perilous than that, is my submission. Yes, we have a problem. We have a problem. We have the 10th schedule. Is the 10th schedule a perfect solution? No, it's not. It has its leaks. Parliament is, when the legislature sometimes tries to fix it. Sometimes there are conflicting interests. It is not fixed. Malad, the biggest example we have of criminalization in politics. We've had this problem all the while. We have problems about election donations. We have problem about election funding. We have problem about election spending.
Stature versus stature.
These are all problems, Malad. We can't cross beyond a point. So, my lord, first of all, I submit the first set of cases don't arise. Then comes the second situation. What did the governor do? He is left in Maharashtra without a chief minister. If he is left in Maharashtra without chief minister, he has to invite somebody to form the government. Now, he had then two options. He has invited Mr. Shinde to form the government. Should he have not allowed Shinde to continue without a floor test? That would have been worse than conducting a floor test. Where are we in this case? Everything is academic. Yes, the only thing which remains is the 36 pending disqualification petitions, which the speaker will decide. And if he gets them wrong, there is the High Court which will correct them. Your lordships are here, which will correct them. We have, within the parameters of judicial review, your lordships have tested and corrected these orders time and again. That is, my lord, my first submission. My second submission is what happens pending the disqualification petitions. Your lordship has been shown the judgments, but let's, my lord, sometimes it helps. Let's go back on first principles. Please see two provisions of the Constitution, my lord, and whether your lordships find the answer there. 190.
Yeah, we've seen that
The
actually.
only point.
Your lordship has seen it.
We've seen it.
Correct, my lord? The point which I wanted to make is just show your lordship something in the language of 190, just for 2 minutes.
190 is Parliament. We are more concerned about 180. Is that 69? No? 160.
The language is identical. I mean,
Identical. Correct.
yes, there's no. The principle of the two is very important. Let's see the compare the equivalent provisions. First see 173. These are qualifications. Person not qualified to fill a seat. I don't need to trouble your lordship with the details. And then we come to 190, which is houses of the state of legislature. So we are really concerned with 190 because we are talking about state. And 190 sub-article 2 tells your lordships, no person shall be a member of two or more specified, then after the expiration of the period, etc. We are not concerned because we are really concerned with sub-article 3A, becomes subject to any of the disqualifications in 1 or 2 of 19 of 191. So we may not go to 191. 191 applies to at both stages for being chosen and for being a member. We see our post occurrence of events. Unsound mind and stand so declared by a competent court. A pendency of a petition in a court to declare somebody incompetent is not good enough. In pending insolvency is not good enough. Look at E now. If he is not so disqualified by or under any law made by Parliament. Now, my lord, today your lordship was told eloquently of how terrible it is to allow those hit by 10 schedule to continue. My lord, it is not every time that there is corruption because of which there is defection. There may be times where people may defy a whip There may be time when there may be a split in a political party. Now that sub-article 3 has gone, you have a problem. And people may say, we will brave disqualification, but this chief minister has to go. But look at, my lord, the Representation of People Act. You may have a person who's elected on which there are allegations of booth capturing, of violence. I remember, my lord, once somebody was arguing the case for one of the persons from Bihar, my lord, who was in jail, and saying he should be allowed to come. Mr. Tulsi was arguing, and he told Justice Nanavati, he said, see the majority by which my client has won the election. And Justice Nanavati said, if your client had his way, he would have had no opponent. He would have killed all of them. So, my lord, those kind of cases are pending. A person, my lord, a known mafia king, against whom there was a murder trial pending for publicly gunning down people, continued in office.
Where does it?
My lord, we have cases, and your lordships have dealt with these cases in the High Court and sometimes in appeal in this court. You have cases of the worst kind of electoral offenses pending for trial. What happens to those people? They continue in office. So, my lord, there is nothing so shocking that in our system, many times people continue in office where there are serious allegations pending against them. That's the bane of our system.
Thank you.
Thank you. Thank you, Mr.
Now, with that, my lord, see the language of 191(2). A person shall be disqualified for being a member if he is so disqualified under the 10th schedule. So that disqualification must take place. And that disqualification in the 10th schedule does not take place until there is a decision of the chairman or the speaker under paragraph 6. Any other view, my lord, would be equally or would be far more disastrous, because today all you have to do then to paralyze the working of an assembly is to file disqualification petitions.
Mr. Salve,
Yes,
till here there is no problem.
yes,
The position under the Constitution is very clear,
yes,
and also the judgments of this court.
correct.
Concluded with this expression, the decision.
Yes,
The problem arises the time, context, and the stage at which speakers choose to take a decision.
yep. I was going to straight away address, but
Where are
yeah,
we?
so
I mean, in
yes,
that,
yes,
it is in that context that
yes. Now, my
either
lord,
that either that he shows over anxiety to immediately decide violating principles of natural justice, or he just doesn't decide for times to come.
my lord,
So,
the
in
short
the field
answer,
of pending 10th
yes,
schedule proceedings,
yes,
the powers to be exercised either by the governor or the political process, as it were, goes on.
yes.
So makes the application redundant many a times.
May I, my lord, respectfully
Please
answer?
also.
This has been the biggest problem of appointing a speaker. Mr. Sibal was right when he said your lordships expressed hope and faith that the institution of the speaker will rise above politics when it comes to the 10th schedule. Our experience may not have fully risen up to those expectations, but that's where we have to drop that. The point, my lord, is this.
Yes.
But not the respectfully answering Justice Narasimha's question. If your lordship has seen, the rules here have in one sense a constitutional status because the rules are framed as a delegate under paragraph 8. And those rules can and should provide a time frame in which these petitions have to be decided, both giving fair opportunity. So these rules normally say you will give so much time for giving a reply. One of the reasons why our group came to court is even that time was not given. And equally, perhaps its time has come for the rules to say, if a petition is filed, he shall, unless there are compelling reasons to the contrary, dispose it off in 90 days or 60 days or something like that. And there, my lord, then judicial review will come in. If a speaker is dragging his feet and the rules say he must decide it absent compelling reasons within a given frame of time, judicial review will come in. You can go to a high court and say, issue a writ of mandamus directing him to dispose of, because then you will have a legal right to ask for a decision within a given time. So, my lord, these are the only ways in which your lordships can address this lacuna. Now, what is the relating back? Relating back has two dimensions. The event has taken place. So ultimately, subsequent events will not affect, it will not efface the wrong which you have committed, the political wrong which you have committed, which disqualifies you. It's over. My lord, if you enter into an office of profit, you're disqualified. If you resign 3 months later from that office of profit, it is not saved. You're disqualified on that day. So, my lord, that disqualification is based on a set of events. But please consider the consequences, which will be contrary to the terms of the Constitution, which says no act of the House shall be declared invalid merely because a member participated who was not entitled to. Now, first of all, here you are entitled to participate, but even if a wrong person comes in, you cannot go annulling the work being done. Today, my lord, when the defection petitions are decided, if some of them are allowed, in between laws have been made, resolutions have been passed by the House, all of them can't be revisited. So, my lord, that's the respectful answer to the ex post facto point. That as a matter of law, and my lord, I read, since your lordships have kept this question back.
What were you saying, Mr. Salve, as a matter of law?
As a matter of law, my lord, I read the Nabam Rabia judgment not as laying down an absence of power, but as laying down a code of conduct. Let me explain what I mean, my lord. The speaker is...
On the ex post, Mr. Salve, in a sentence, can you just summarize your ex post facto on ex
Yes.
post facto? What is your, so we'll
Lord,
just, if you
yes.
formulate it, we can take it down
Yes.
then, you know.
My formulation of ex post facto is as follows, my lord. The disqualification will have to be decided on the basis of the acts and omissions of the allegedly delinquent member on that date. But subsequent events will not cure that. If on that date you defied a party whip which was lawfully issued, that's the end of the matter. The fact that the party collapsed thereafter is neither here nor there. If it is pursued
Yes.
to its logical end, that wrong has been committed. And I give, my lord, the example of somebody who takes an office of profit. Let's get into
If you can just
non-controversial.
continue to sort of complete the formulation, I got that the
Answer,
disqualification will have to be decided on the basis of the acts and of omissions of the allegedly delinquent member on that date,
when he
And
committed
subsequent
those
events
acts.
will not cure that.
Will
What
not
the
efface,
call also said.
will not efface.
What is the sequitur?
Yes.
What is the
But the
sequitur? How do you
sequitur is,
formulate it?
however, until the date of decision.
Yes.
The person is entitled to participate. And Article 189 subarticle 2 makes it clear that his acts, his functioning in the house in the interregnum does not vitiate any actions of the house. If this is so, my lord, we have no problem in reconciling to the fact that people with the most serious allegations of having been elected by wrongful means such as booth capturing, threatening witnesses, or rampant corruption in election also continue in office. That's one of the banes of our system till such time as a election tribunal declares them to be wrongly disqualified. That's the way it is. So, my lord, my respectful submission is that yes, the rule should be amended. Speaker should, decision making should be made time bound. Judicial review will be available where a speaker is holding back. All those are ways which we can fix this. But my lord, the legal consequence of the pendency of these proceedings and its ultimate decision, this is the principle of ex post facto which must apply. No less, but no more.
Anything else, Mr. Salve? We got the
Yes.
ex post factor now.
Third point which I wanted to make, my lord, is since the point is still in play, the Nabam Rebia judgment, and I had, my lord, given a note earlier. I believe Mr. Trivedi had handed it over. Mr. Jetmalani had handed it over.
Last time you read also when you appeared.
Yes, my lord. No, after that I gave a note, my lord.
That was there.
I read the judgment as more not the absence of power, but the manner of its exercise. So it is by filing a disqualification or rather a removal of speaker, because all those provisions are shown to your lordship saying the speaker doesn't, as a matter of law, is not put in suspension. They are right. So there is no absence of power. I was not only saying,
It's about the manner of exercise rather than the absence of power.
correct, because my lord, abuse of constitutional power is a head which we now recognize for judicial review. Is my lord the Chief Justice saying something to me, my lord? I can't hear.
You don't read Nabam Rebia as an absolute principle that the speaker is disabled from exercising his jurisdiction when there's a motion for his removal pending.
No.
It's a caution to the speaker, and ultimately it's for the speaker to take a call whether there's a frontal assault on his continuance, whether he would like to go ahead with the hearing of the disqualification petition.
And as I read that judgment, my lord, your lordships have not said that the speaker ceases to have power, but
So
the
what you're
manner
telling
of
us would be either to sort of restrict it a little bit or put a gloss on the judgment. I mean, if you really read those,
my lord, we always judgments are not statutes, and we always learn to understand them. Sometimes when things are written, my lord, those facts were very stark, so maybe the language used was a little strong. But I read that judgment as, because please see, my lord, the analysis, and your lordship has read the judgment. I'm not going to waste your time reading it. The facts were so stark. What really your lordship was doing is that are saying is that the speaker had no business to do this. The actions of the speaker in that case, my lord, were open and shut case of abuse of power, is the finding. So I don't, my lord, read that judgment as absence of power. Your lordship never said that he ceases to have. There are 50 other things the speaker does, my lord. He runs the whole administrative office of the legislature. Surely he's doing all that. It's only in one area that the speaker should not act. If there is, my lord, pending consideration of all these rumpus, if there was any other resolution, of course he would preside and run the house. So, my lord, once your lordships read that judgment that way, that what really the court was trying to say is not an absence of power, but the actions of a speaker will be tested. A speaker should be put to caution when there is a notice of his removal. His actions will be tested on well-known principles of abuse of power. Then, my lord, the concern which your lordship have would go away, with that judgment being read as absence of power. And finally, my lord, if I may just hark back a little to my first opening point, apart from this understanding of the Nabam Rabia judgment, my lord, nothing else really survives. There is a note which I believe is placed at note J. My lord, I believe, I'm sorry, my friend informs me, my earlier note saying what I have just formulated for your lordship's consideration is in note F. And there is yet another note, note J.
Last night.
Yes, this is only to show the hazards of the but-for test.
Note J.
I was just told, my lord, it is marked as note J.
It is written submissions. It doesn't say note J.
It says brief note on arithmetic for hypothetical trust vote.
What's that?
Mathematics.
Yes, it's just the math. Only, my lord, this is only to indicate to your lordships that this but-for test is extremely hazardous. To guess what would have happened on that fateful day had a trust vote taken place is
What is this
inviting
note?
rank speculation.
I got
Yeah, yeah.
Harish Salve's name. J.
ये J अलग है। Harish Salve का पहले का।
F is the earlier one on the Constitution Bench judgment, the Nabam Rabia judgment.
दोपहर को कर दे दोपहर को हाँ कर दे
हाँ.
हाँ प्लीज
And this note J, my lord, only sets out, I'll quickly tell your lordship what we have basically said.
Notes to there are.
नहीं है वो अलग है
I have given, my lord, different places where in the writ petitions they have mentioned.
You sent it on my mail, personal mail, na?
Basically, my lord, this gives you at one place. Please, it's not there, it's no big deal. Your lordship knows it is there. Basically, what we are trying to say is, we have given your lordship the para numbers and the page numbers.
तो डाउनलोड कर देना बाद में उसको
Thank you.
If your lordship sees the from paragraph 3,
नहीं.
Email ID thing.
On 23rd June, only 16 disqualification petitions were filed. Let's be very clear, my lord, of a few dates. On 25th June, Speaker issues notice to 16. The order of your lordships on 27th June was limited to 16. The suggestion that, my lord, there was 39 or 40 disqualifications. In fact, my lord, look at 4C. There are two of them who are independents. They may vote one way or the other. Their party to decide whether they consider it a breach. No prayer in any of the petitions that 39 or 40 should not be allowed to vote. So, my lord, these figures which are being given, and I've given your lordship the shifting stands in different places. And I, my lord, again underscore the point. This was only
Mr. Salve, Mr. Sybil, Mr.
To
Paul,
finish,
Mr.
Malad,
all of you.
please.
What you were thinking was that Mr. Salve, roughly,
I'm done in 5 minutes.
That's all right. But it won't finish now.
Yeah.
Can't finish. There's no point.
Mr.
Malad.
Salve, you will take about
5-7 minutes.
5
I'll be done by
Okay,
lunch.
5,
Yes,
7 minutes.
100%.
Mr. Jethlani, we are not at all rushing any one of you because these are important matters of moment. We are not just forget the facts, but we are thinking of a matter of a moment. So, how much would you take in terms
Ordinary circumstances, about half an hour, but I could curtail it to 20 minutes, 25 minutes.
half an hour? Then Mr. Maninder Singh, half an hour, all right. Mr. Solicitor,
Are a few more minutes, fellow.
about between the three of you will take 2 hours.
Realistically speaking, it may not be over.
All right, Mr. Call, one more thing. I thought we curbed you unduly, and then you were gracious enough to follow our edict. But the idea was to finish today, but we may not be able to wrap up today.
Yes,
Now,
yes,
it doesn't
no
appear that we'll be able to wrap it up today. In which case,
Then
Mr.
let's
Call,
have it on Tuesday then, Malad.
Mr. Call, one more thing. Is your conscience clear that you're satisfied that you've argued fully? Is there something which you would have still liked to? Because as a judge who's seen so many seasons,
Never give
I
that
don't want you to
opportunity
leave.
to a lawyer, Malad.
You don't want to give the impression that you're not.
Ideally, I would have liked to take your lordships through some of the judgments if I could, which I rectify. But what do I say, my lords, to this? I can't. I leave it to your lordships. I can't say.
All right. What we will do is this: we will hear Mr. Salve now and just wrap it up, or we can. क्या करें?
Well, let's wrap it up and then have it on Tuesday, Malad, after reopening. That's the only way, Malad.
On the reopening. Reopening.
Then do is that on Tuesday,
On reopening.
after we reopen, the three of you who have to now argue, and honestly, if there's something you want to still show us in the morning after Mr. Salve has wrapped up, we'll give you a little time
Very-
so that
very-
you don't
very-
feel that,
Well,
And anyway, there's no prejudice to Mr. Sibal because you still have to rejoin. So,
Yes, yes, normal, I'll sort of rejoin without the
would
haste.
would it be all right to assess that on Tuesday in the first session, the three of you will be able to finish?
Yes. Yes.
Right? Maybe so if you take.
But are we not continuing this afternoon also?
I
No,
think
no,
there's
no
point
need,
because they're
Madam.
now going spilling over beyond the.
Oh, yes.
There's
So
no
then
point,
we'll get some more time also if it was.
isn't it? Then what we can do is we can keep it on Tuesday. Mrs.
Yes.
Salve, we'll hear you for 5 minutes on Tuesday.
Yes, yes.
You may want to just.
Very well.
And then, Mr. Paul, if you still want to make a few submissions in your judgment, no problem. We'll hear you on that because let's not go.
They're very kind of your lordships, very kind.
Then Mr. Jeffnani and Mr. Maninder Singh, and then we'll hear the governor, Mr.
After, my lord,
Kulbhushan Jadhav.
I'll,
And equally, Mr. Sibal, we'll give you a full.
That's right, because there's lots of things that have been said, Malad, which.
Mr. Sarode, what is that you wanted to say now? And don't mention anything, huh? We're not, this is not mentioning time.
No, Milord. Milord, I am intervener on behalf of the voters. I may be given some time to, Milord, narrate the.
Mr. Sarode, if you allow interveners, then there'll be
Whenever
no
possible,
issue.
Milord.
There'll be interveners on this side, interveners on that side.
no
Give us a
problem.
small note of a page or so. We'll look at your note. No difficulty. Just
No, Milord,
listen.
I'm supporting Mr. Sibal sir and the party, Milord. But Milord, voter side is very important as allowed by the honorable
Mr.
court.
Sarodi, Mr. Sibal will be, Mr. Sibal and Dr. Singhvi will be very happy with your support, but I'm not sure they want you to support them in the court. So you can have a word with Mr. Sibal. If you have some specific point, which they have not covered, then you can
Yes.
certainly have a chat with Mr. Sibal and give that point to him, and I'm sure he'll place it before us.
Yes, Milord, I will do that.
Very well then, Malad, Tuesday, I'll take 10 minutes.
Which Brother Narsima has also, we have both been discussing this also earlier. Justice Nariman's judgment on whether there should be a time limit on the speaker to decide
Yes, Malad,
what
that-
referred.
I was going to cite that, Malad.
If we can, yeah. And maybe we can
I'll
have some
assist
thoughts
your lordship on that, Malad, on
on
Tuesday
some
for 10
thoughts on
minutes.
that so that
Just
we
note
can.
the reference order is you can note.
And then-
2016 SCC online 1875.
That's Sampath, Malad. That's Sampath, not this. This is something different.
Megachandra's separate.
This is,
Megachandra's reference.
the other one, the other issue is, Malad, where 90 days have been fixed by Justice Nariman for the speaker to decide.
Correct.
That's not that 2016.
I thought this is the, I just got it from my law clerk. That must be a separate reference.
That's right.
Is considered in that judgment.
Please work on.
Yes.
Lordship, please.
Tuesday.
Tuesday.
Very grateful.
Obliged, Malad.
Deeply obliged.